requesting the petitioner to show cause.
Sorry.
Or clause B.
This one.
148. Show cause.
This final order.
To show cause under section 148 with regard to deposit of rupees 72 lakhs
20,000 21,300
1,300 which was made in the financial year 2016-17. Stop. Mr. Kepal submits that firstly the writ petitioner is a member of the scheduled tribe and is exempted under section 10 paragraph 26 of the Legality Act, and further that the cash deposit mentioned in the notice refers to accounting year 2017-18, financial year 2017, which is more than 3 years, from the date of the notice. Stop. He therefore prays that in the interim the impugn notice be suspended.
But there's a final order, Milits.
The final order?
The order is at Milits, page 51, Milits.
Just told that 51. What reason have they given?
I'm sorry, Milits.
What reason have they given for?
Milits, what they say is that they've now raised an assessment order asking us to pay, Milits. At page 59, my lords would find it.
Not a show cause to think.
It is dated 20th of January 2025.
Show cause notice is 21st March.
2024, my lords.
Okay, 24. Sorry.
So after we filed, my lords, and reply saying that I am exempt, they passed this assessment order.
No, before that. Score out the thing that the issue notice. So. No, impugn order dated
20th of January
2025.
Page 62 is the
Pass under section 147, read with section 144 capital B of the Income Tax Act, wherein the petitioner has been found liable.
Page 61, 2 crore 5 lakhs.
Yes, where is that?
Page 61.
61, my lords. That is the computation sheet.
Yes.
Starts from page 59. The demand is at page 62, my lords.
Yes, this has been found liable. C bracket 1 of the Income Tax Act 1061. Stop. Mr. K. Paul, senior counsel for the petitioner, has submitted that firstly the petitioner is exempted from payment of income tax by virtue of the scheduled tribe as per section 1026 of the Act. To the notice under section 148, it is submitted that the counsel petitioner a prima facie case is made at this stage for issuance of interim orders. So, stop accordingly. Until the next date, the impugned order assessment dated 21/20 shall remain stayed. Stop. This on so and so.
All right.
Daily list item number 1.
Lordship, there is a delay of 16 days, Lordship. Lordship, application may be allowed, Lordship. I don't have enough question.
16 days, my lord.
16 days.
16 days.
You're for the petitioner?
My lord.
You leave to appeal. You are not.
Lordship, Lordships had granted that on the last date, 3/4/25.
Yes, this case, number 42 of 2024. 42, right, is the condition application?
Lordship.
Yes.
42.
Yes, Mr. Kibi Prasad appearing for the respondents, Mr. Government for the respondents 1 to 6, Mr. H.L. Changreso for accounts for 7, and Mr. S.A. Sheikh for respondent number 8. Have no objections if the continuation is allowed. Accordingly, for the reasons stated in the application, the delay is condoned. The delay is condoned. Stop. Registry to diarize. Registry to diarize and register the immediate appeal.
31st July, Lordship.
See in the first paragraph 31(8).
Lordship, typographical error, Lordship. This one.
Problem? Of 101 days. 2024, passed by learned single judge in WPC 390/2016. You correct this? Yes. It is submitted by the learned counsel petitioner that the delay has been caused due to unavoidable circumstances. It's now been further submitted that the matter is also connected to other writ appeals which are pending here, where the same order is under challenge. Stop. Next paragraph. Mr. K.B. Bhattacharya appearing for the respondents number
1 to 6.
Mr. S.A. Sheikh number 7 have submitted they have no objections, as connected matters also pending consideration before the division bench. Stop. Accordingly, the delay of 101 days is condoned and registry is directed to diarize, register the appeal for admission. This case on this point. See, courts rely on assistance given by the advocates. Sometimes they say so respond, we don't even look at the papers, we what to say? We take the word as gospel truth. Same thing only, same party.
My lord, here we are challenging the legality of the act, my lord. The issue involved in this case is, my lord, was whether the assent given by the governor without the bill placed before the elected MTC.
The assent given by the governor?
By the governor, without, my lord, placing the bill written by the governor before the House for deliberation voting, vitiates in the act itself or not, my lord. That is a short issue involved, and it is important. The brief facts, my lord, I will straight away, with lordship permission, page number 21. My lord, in 2015, the amendment bill was introduced.
1 second. This which SIMship?
My lord, this is the Maharam SIMship. My lord, in the first paragraph, inviting reference to your letter cited above, I am directed to say that the bill, namely nomination election of a CM, Deputy CM, and electors of Hima Maram, Second Amendment Bill 2014, has been examined by the Law Department, has been consulted, and its view is reproduced as below. Now, at the end, my lord, in view of the above observation, the amendment bill is returned herewith for doing the needful. So the bill was returned to the District Council, and thereafter, a demo was made in page number 24. The new bill was introduced, and, my lord, the proposed bill was published, page number 24, in 2019.
Yes.
My lord, the name of the bill is, my lord, the Khasiels Autonomous District Nomination Election of CM, Deputy CM, and Electors of Hima Maram, Amendment Bill 2019.
Yes.
So this was published as per the Act. And, my lord, page number 34. My lord, Governor Pavan has written to the District Council Affairs, forwarding my objection, page number 34. on 10th.
Yes.
My lord.
Yes.
And thereafter, my lord, page number 36. My lord. The state respondent has sought clarification from the district council regarding the bill. Address to Secretary Exit Committee.
Yes.
And thereafter, page number 37 or so, similar clarification sought.
Yeah.
And thereafter, my lord, page number 38, it is a similar letter. Now I would come to page number 39.
Yes.
Here, page number 39, the Deputy Secretary of the Council has written letter to Secretary of the Council that with reference to subject cited above, I am to inform you that due to typing error from the office of the Council's Autonomous District Council Legislative Secretariat, that the word land regulation, the word land administration in subsection 1 of the proposed amendment bill forwarded by the Executive Committee, Council District Council. Therefore, you are kindly requested to rectify the same and to take up necessary action from your end. My lord.
What is the objection? What's the basis of your objection? You have not touched upon that.
My lord, I placed my objection.
No, what is the objection?
Objection, my lord, the bill has altered the customary practices.
In which manner?
My lord, for example, the tenure of the headman. Once
That's the only amendment that is made.
3 years.
And
And
the
second amendment,
objections-
third amendment is, my lord,
Only amendment that is made.
3 years.
And
And
the
second amendment,
objections-
third amendment is, my lord, the bill was the Law Department of the Governor of Meghalaya, after careful examination of the bill, has made the following observations. The proposal, but passed by the Council on 25th July, my lord, received the assent of the Governor on 15th September, my lord, received the assent of the Governor on 15th September, my lord, kindly say, 2023. Published in the Gazette, Now, without placing the return bill before the House,
Now, what has happened here is that they have omitted that part.
they omitted the part.
Wait, this so amendment, let us read it carefully.
This point 2, point number 2 sought for omission, and number 3 require for amendment.
So only these two, the Mintri, Binod, Rambashnong, also writes House and Pair, and the
Yes.
proviso that 3 years.
Yeah,
Those are the
3.
things that
And
remain.
to the Governor for assent. After the bill has been signed by the Chairman, Secretary shall send an authenticated copy to each of the following: to the Executive Committee for information, to the Governor for information through the Secretary, District Council Affairs, Department Government of Meghalaya, if the bill does not require the approval of the Governor, being not so specified in any of the provision of the. Page number 39 and 48,
Now they given us
running page.
this is former revision of bill. You're referring to rule number 92.1, correct?
Yes, 92 and 93 I'm referring.
Yes, please read again.
Well, to the Governor for information through the Secretary.
No, when a bill has been passed, which is the council secretary shall, read from that
My
part.
Lord. Yes,
92.1. You start 92.1.
92.1, my Lord. Yes, 92. When a bill has been passed by this District Council, the Secretary shall, if necessary, is submitted as in Rule 92.2.3 and is returned by the Governor with a message to the District Council for reconsideration. The point or points refer for reconsideration or the amendments recommended shall be put before the Council by the Chairman and shall be discussed and voted upon in the same manner as amendments to a bill, and it shall be presented again to the Governor for his assent. Now, my humble submission now, once the Governor has recommended or sent back the bill with a message of recommendation, amendment or the reconsideration, but that reconsideration amendment is the duty of the lawmaking body. The
You
floor
mean
of
to
the
say, suppose the governor has just given a remark
Yes.
that this does not fall in the ambit of the Parent Act.
Well,
Delete it.
well, therefore the
So will
Governor.
that amount to reconsideration of the bill?
Therefore, the Governor has identified that the Amendment 2022, the scope of the Parent Act, Therefore,
only in one clause.
oh, yeah, one clause.
Proviso that. Yes.
My lord. So this, my lord, to remove that one, it is the basic legislative duty, lawmaking duty. But now it says the rules say discuss and vote it. My lord, my humble submission, the wisdom of the elected members need to apply to discussion and voting. And once they adopted the bill will go back to the governor. Now what they have done is, my lord, once they receive the bill from the governor, instead of placing before the floor of the house, whatever modification, amendment the executive committee has done it, and sent back to the governor, and governor has given his assent.
You're sure there was never a place for the house?
Therefore, the district council affidavit itself admitted that fact. May I just place the council affidavit? Well, council has filed the affidavit on 28 Feb 2024. My lord, I may take your lordship permission to paragraph 7. My lord. With lordship permission, may I read?
Yes.
The statement made in paragraph 9, 10, 11, 12, 13, 14, 15, and 16 of the petition is admitted only to the extent those are based on relevant record. It is stated herein, the communication referred to it herein and the facts narrated in the paragraphs do not have any bearing on the question of powers of the Act of 2019. It is stated that the legislative wisdom of the Khasi Autonomous District Council cannot be subservient or put to scrutiny by any forum of the executive state. The bill as passed by the House, having ultimately received the assent of the governor on such, has been published in the Meghalaya Gazette, and these admitted facts being germane to the issues regarding procedural validity of the passage of the bill into an act, no fault or infirmity is visible in the entire process as to the question the validity of the Act of 2019. Now, the annexure they brought, my lord, page number 8, Council, the Proceeding of the House, paper, page 8 onward, my lord, annexure A. Page 90, with lordship permission. Yes. I am directed to forward herewith the Khasi Hills Autonomous District nomination election of the CM, Deputy CM, and electors of Hima Maharam Amendment Bill 2019, passed by the Khasi Hills Autonomous District Council on 25th July 2019, which received the assent of the governor on 15 June 2023, with a request to have the same published in the Meghalaya Gazette and to provide 50 copies of the census.
Yes.
So governor himself admitted that the bill was passed on 25th July 2019, and he has given assent. So in between, my lord, 27 July 2019 to 15 September 2023, there was no session regarding this bill for reconsideration.
Where's the reconsideration in petition again?
My lord.
The letter of the
Yes, sir.
Council Affairs. This at lecture of page 40.
My lord. Page number 40.
It's not reconsideration.
Page number 40. Governor has given for reconsideration, page number 40, and they have notified on page 41. So, number 1, my lord, page number 40 is a very vital, is a changing of the bill, the Act is amendment bill itself. It is not just simply an arithmetical mistake, my lord. If my lord House put it in the first proposed House put it in the first proposed amendment bill, now whether that amendment bill, now whether that to be required to be deleted requires the wisdom of the House on the floor, my lord. So this is purely, my lord, the removal of this land administration from the bill is indeed, my lord, a legislative duty, not executive duty, my lord. Therefore, my humble submission is, my lord, without placing the bill and get the assent,
observations. That will be examined also. He's going to be hyper-technical. Yes.
my lord. Therefore, this is my humble submission. This amounts to depriving the House, the Executive Committee, and the government of the elected members, and notify the Act.
You
Therefore,
mean to say that,
it vitiates.
fine, the governor did not ask for reconsideration. The letter says that it's observed that proviso 3 whatever land administration is not within the the ambit of the.
It's not the procedural irregularity cannot vitiate the Act. Legality cannot vitiate the Act, my lord. And therefore, Lordship, in some time to all of us, with Lordship permission, I will place four decisions of the Supreme Court, my lord. Here, my basic contention is, it is not only a procedural irregularities, but it is, my lord, the abdication of the elected members of the district council, abdication of the power of the
Application of power.
powers of the lawmaking body.
Okay.
Now, with regard to the, my lord, the assent and the approval of the governor or the president, my lord, I will place first, with Lordship permission, keep the citation. My lord, may I just place I down? My lord, this judgment with regard to Assam,
The very famous judgment as
my
well.
lord, it is a famous judgment, Lordship, correct, my lord. If Lordship permits me to go to para 52, 61, 78 and 98, my lord.
5261.
Yes. 87 and
No, you just give all the paragraph. You're going to rely upon 52,
my
61.
lord, paragraph 52, 61, 78 and 79.
79.
My lord.
Okay.
Atyab. My lord. Para 52. The running page we marked, my lord, 35.
Yes.
Page number 35. With Lordship permission, my lord.
Yes.
Incidentally, we may observe that the difference in the provisions contained in Article 302 and Article 304b would prima facie seem to suggest that where the Parliament exercises its power under Article 302 and passes a law imposing restriction on the freedom of trade in the public interest, whether or not given the law is the public interest may not be justiciable, and in that sense, Parliament is given the sole power to decide what restriction can be imposed in public interest as authorized by Article 302. On the other hand, Article 304b requires not only that the law should be in public interest and should receive the previous sanction of the President, but that the restrictions imposed by it should also be reasonable. Prima facie, the requirement of public interest can be said to be not justiciable, and it may be deemed to be satisfied by the sanction of the President. But whether or not the restriction imposed are reasonable would be justiciable, and in that sense, law passed by the state legislature may on occasion have to face judicial scrutiny. However, this point does not fall to be considered in the present proceeding, and we wish to express no definite opinion on it. My Lord, 61. I'm just referring the background, my lord. Here, the present sanction was not obtained, my lord. Page number 41, my lord.
Yes.
Paragraph 61. In the result, we hold that the Act has put a direct restriction on the freedom of trade, and since in doing so, it has not complied with this provision of Article 304b, it must be declared to be void. In view of this conclusion, it is unnecessary to consider the other points urged in support of the challenge against the validity of the Act. The 3 appeals and the 2 petitions are accordingly allowed, and the writs or orders directed to be issued as I prayed. The appellant and the petitioner would be entitled to their cause from the respondent. May I travel to relevant para, my lord, 78 and 79. That is page number 50, my lord.
What was the point you're trying to make with regard
My
to...
lord, it will come, my lord, if lordship permits me. Para 78 and 79, my lord.
Yes.
As observed hereinafter, the previous sanction of the President was not obtained to the moving of the bill, which was enacted as the Impunity Act. Even though the Assam legislature had by item 56 of the 7th schedule legislative authority to impose this tax, the state cannot exercise this authority in absence of the previous sanction of the President. and the invalidity of the act imposing the tax on goods and passenger is not cured, the President having not assented to the act at any time after it was passed by the state Assam legislature. The argument that this view will seriously restrict the sovereignty of the states has, in my view, little force. Even a cursory review of our constitutional provisions clearly shows that the primary object of the Constituent Assembly was to erect a governmental machinery with a strong central government, with the object of building up a healthy economy and independent states, consisting of the former British Indian provinces and the merged Indian states, by subordinating local and parochial interests to the wider national interest. In any event, adjudicating the virus of a statute, the impact of the view which the interpretation placed by the court may produce on the same cherished notion of the sovereignty of the component states must be ignored. In that view, the Assam tax on goods carried by roads and inland waters Act 1954 must be regarded as infringing the guarantee of the freedom of trade and commerce under such because the famous judgment, my lord, regarding the 10th schedule matter, my lord, 1992, supplementary 2, amendment of the 10th schedule, my lord. But this required ratification by the states. Now the act was passed by the parliament and the ratification was not obtained. And the Supreme Court held, my lord. Relevant para may refer para 60, my lord, 61, 63, and 186.
Yes.
My lord, may allow me to refer to page number, the para 63, my lord. Of a constitutional power and differs in content from the legislative power. The limitation imposed on the constitutional power may be substantive as well as procedural. Substantive limitations are those which restrict the field of exercise of the amending power and exclude some areas from its ambit. Procedural limitations are also which impose restrictions with regard to the mode of exercise of the amending power. Both these limitations, however, touch and affect the constitutional power itself, disregard of which invalidated its exercises. Para 65, my lord. Although there is no specific enumerated substantive limitation on the power in the article 65, my lord. 65, my lord. Although there is no specific enumerated substantive limitation on the power in Article 368, but as arising from very limitation in the word amend, substantive limitation is inherent on the amending power, so that the amendment does not alter the basic structure or destroy the basic feature of the Constitution. That the entire 10th schedule is constitutionally invalid in the absence of prior ratification in accordance with the proviso to Clause 2 of Article 368. That the doctrine of severability does not apply in the present case of a constitutional amendment which suffer from the fact of absence of ratification as required by the proviso to Clause 2 of Article 368. That the remaining part of the 10th schedule minus paragraph 7 is also unconstitutional for violation of a basic feature of the Constitution, and that the entire 10th schedule is therefore unconstitutionally invalid, rendering the Constitution 56 Amendment Act 1985 stillborn and an abortive attempt to amend the Constitution. In view of this conclusion, it is not necessary for us to express our concluded opinion, my lord. So my humble submission, my lord, here also Apex Court said that ratification from the Legislative Assembly of the states, it's a lawmaking process. Now, depriving this, my lord, in that case, amendment of the Constitution is invalid. In my case also, my humble submission, without placing the return bill to the House for deliberation and voting, my lord, is a substantive violation of the lawmaking power of the District Council, my lord. And the next judgment, my lord, 2013 Volume 1 SSC, page number 745. Well, this with regard to the appointment of the Information Commissioner under the RTI Act, validity of the certain act of the Information Act 2005 was challenged. And my lord, in view of this, para 11 of the judgment may refer. Para 11, my lord, running page should be 766.
Para
11, my lord.
766.
My lord, 766, running page, my lord. And at the bottom, my lord, the last paragraph, 11. May refer, my lord. May refer. An enacted law may be constitutional or unconstitutional. Traditionally, this court had provided very limited grounds on which an enacted law would be declared unconstitutional. They were legislative incompetence, violation of Part 3 of the Constitution, and reasonableness of the law. The first two were definite in their scope and application, while the cases falling in the third category remain in a state of uncertainty. With the passage of time, the law developed, and the grounds for unconstitutionality also widened. Titi Pasu in Shorter Constitution of India has detailed, with reference to various judgments of this court, the grounds on which the law would be invalidated or could not be invalidated. Reference to them can be made as under. May I take to my lord number 3, Roman 3. Contravention of any of the mandatory provisions of the Constitution which imposes limitation upon the powers. My lord. And fifth, my lord, that the legislature.
Now, only one thing, will observation amount to?
That the legislature concerned has abdicated its essential legislative function as assigned to it by the Constitution, or or has not made an excessive delegation of that power to some other body. Now, according to me, my lord, the floor of the House was deprived, or the District Council Committee has deprived the lawmaking authority of the Council. My lord. So this is also relevant, my lord. And the last citation we may please, my lord. 2016, volume 5, ACC page number 1. It's advocate on records case, my lord. NJSC case.
Which is given under the Constitutional Council rules, we will consider the thing as per observation of the so that's the thing. Yes. Yes.
My lord. May I come to relevant para, my lord?
Of
2016 5 ACC.
Sorry, 2016.
2016 volume 5 ACC 1. NGSC case.
16 volume 5.
Page number 1.
1.
Yes. The entire volume. My lord, relevant para, may I start from page, the paragraph 865. In Sitiluhu, SSC, my lord, paragraph 61, 62. My lord, paragraph, my lord, 856.
Show me that 1961.
God. What did I tell you?
Page, my lord, 643.
Sorry. I mixed up in the page and the
My lord.
Yes, please.
Paragraph, my lord, 856. This view was taken forward in Hikuto Holohan case, wherein it was held that the procedure for enacting a law should be followed. Although it is not expressly stated, but it appears that if the procedure is not followed, then the law to that extent will have no effect. In this case, it was held at paragraph 7 of the 10th schedule to the Constitution needed ratification in terms of clause P of the proviso to articles and such of the Constitution. Now I may come to 857. Strictly speaking, therefore, an amendment to the Constitution can be challenged only if it alters the basic structure of the Constitution and a law.
So even if a 6th schedule is amended, if it offends the basic structure, whether we can say that will not amount to, disturbing the basic structure of the. Those are the other things, of course, because it's a schedule.
Right.
It will not amount, it's part of the Constitution,
Part
no
of the
doubt,
Constitution.
but it will not amount to amendment of the Constitution. Yes.
And another paragraph, my lord, page number, paragraph, my lord, 860, where my lord, the contention of the respondent.
Yes.
They're emphasizing this, my lord. They're trying to draw analogy from there, my lord. 160, my lord. Article 2:122 of the Constitution.
Yes. Yes.
My lord. Then may I come to, my lord, para 862.
Okay.
The bottom, my lord. In Rajaram, the sense that the question of the extent of judicial review of parliamentary matters came up for consideration. Speaking for Sons and Such, and himself, he was held by Subpower CGI with reference to CAT. Paragraph 3, madam.
Yes.
Powers of the District Council, Regional Council to make laws. Lordship, very much aware.
Yes,
This power, my lord, reconsideration of the bill written by the governor falls within the scope of this power. And therefore, the subclause 3, the next page, 3, subparagraph 3, is sent by the governor. My lord, all laws made under this paragraph shall be submitted forward to the governor until he is sent to him. By him shall have no force. So my humble submission is, my lord, the assent given by the governor without deliberation by the House is nullity in nature. Therefore, the act we challenge, lordship may interfere with.
So it's basically only the limited challenge you have.
Yes.
That the due procedure as established or as prescribed have been followed.
Yes.
And in view of the non-reconsideration of the bill being placed for the House,
Yes.
I mean the assent given by governor is null and void.
Yes. Easily.
Yes.
The entire foundation of the argument of my learned friend is absolutely misconceived. And I'll just very quickly take your lordships to two documents that would establish this. Well, let's take it a little forward. I'll first take your lordships to page 21 at Annex 2. This is the first time, my lords, they say that the bill was returned in 2015.
21, yes.
My lords.
Should do, yeah.
May I just read this, my lords? This is Government of Meghalaya District Council Affairs Department, dated the 22nd of January 2015. This is from M. Lingdaw, Under Secretary to the Government of Meghalaya, Secretary, District Council Affairs, Secretary to the District Council, Khasi Hills Autonomous District Council. Well, it's first paragraph is very important. I'll read it a little slowly. In inviting a reference to your letter cited above, I am directed to say that the bill, namely the Khasi Hills Autonomous District Nomination and Election of CMs, Deputy CM and Electors of Hima Maharam, Second Amendment Bill, has been examined, and I'll pause here, my lords, by the Law Department. By the Law Department has also been consulted and its views reproduced below. The bill, namely so-and-so, passed by the District Council is examined, also gone through the objections raised by the Secretary so-and-so against the aforesaid bill. In the objection raised, it is categorically stated earlier act was based on proposed so-and-so. My lords, we can just skip this, and it says, in view of the above observation, the amendment bill is returned herewith for doing the needful. This is the first time they say, my lords. Of course, we brought it on record that the bill went back to the House, it was passed thereafter.
Yes.
The second document which my learned friend is basing his entire argument is on page 40. This is dated the 25th of August 2023.
Yes.
Again, my lords, it is the letters from the Joint Secretary to the Government of Meghalaya to the Secretary of the District Council. Now, my lords will kindly see, with reference to the letter on the subject cited above, I am directed to say that the Law Department of the Government of Meghalaya, after careful examination of the bill, has made the following observations. It is not a case of the governor returning the bill, my lords, for reconsideration, as has been sought to be projected before your lordships. I will take to the averments made by the petitioner before this honorable court. My lords, may kindly have page 10, paragraph 15. My lords have it.
Yes.
That the petitioners state that the respondent number 2, through the Joint Secretary to the Government of Meghalaya District Council Affairs Department, has communicated the observations made by the Law Department to the Secretary District Councils via letter number so-and-so dated 25th August 2023. The Law Department observed that clause 2 of the bill of 2019 may be omitted because of the Principal Act of 2006 has been enacted only to provide procedure for nomination and election of CM, Deputy CM electors, so-and-so, and look after the day-to-day administration of the village and not of the land administration. Further, the Law Department observed clause 3 of the bill also needs to be omitted.
Yes.
So once, the entire case and what we had originally objected to before this honorable court, on which your lordships had granted time to the petitioners, is the virus of any law can be challenged primarily on two grounds: either legislative incompetence or that I'll just take it, my lords. We've placed it on our affidavit. Violation of any constitutional mandate.
Yes.
Neither of these two things are here. Now, the argument of the petitioner is itself self-defeating, my lords, because of the simple reason that had the governor returned the bill, my lords, for reconsideration, and had it not been done, only for the sake of argument, when the governor puts his assent to the bill on the 15th of September, that entire matter comes to an end. If thereafter, my lords, are to examine the validity of that law, my lords, the first question would then have to come is the petitioner would have to satisfy what is his locus to come before this honorable court. Who is he?
Who is he? He's
He's a secretary of a Darbar.
Okay, yes.
That's his limited locus.
Okay.
So if, my lords, I am challenging the constitutional validity of a law, I would first have to establish my locus. That he's not trying to do. What he's trying to say is, he's saying that the governor returned the bill, so therefore 92 came into play. Since it was not placed before the House, the law is bad. Irrespective of the fact that the governor has subsequently put his signature on the bill. As I have said, my lords, the bill was never returned by the governor. It was only returned by the Law Department.
The
through
court
the
has said
District
that
Council
also, not reconsideration, it's observation made.
by the Law Department. It is not from the Governor's Secretariat.
So in cases like that, what does the district council do then? So observation is there and the omission
My lords,
is carried out.
my lords, it depends.
That amounts to
My lords, it
amendment
depends.
of the bill again.
There have been instances, my lords, where observations are, my lords, ignored, or my lords, they're not taken into consideration. And sometimes it is taken into consideration. In this case, it was taken into consideration. One particular document, my lords, which ought to have been brought on record, was not brought on record. This was a letter, my lords, dated the 1st of September 2023, which is again issued by the Joint Secretary to the Government of Meghalaya. It's part of my, my lords, my instructions. I can just place it before your lordships. I'll quickly read it. This is in continuation of that earlier letter. It says, my lords, with reference to the letter subject cited above, I am directed to inform that the Executive Committee so-and-so has agreed and considered the observations made by the Law Department, Government of Meghalaya, as provided under sub-rule 1 of Rule 92 of the so-and-so, as amended, same has been incorporated in the aforementioned bill accordingly. Therefore, the authenticated copy of the bill in duplicate is hereby resubmitted for favor of your information and further necessary action. Well, it's what I'm humbly submitting before your lordships is that the law-making power of the District Council is not subservient to any observations made by the District Council Affairs Department. And that is the settled law insofar as Meghalaya is concerned.
Right, but that by they have acted upon observation. That's the only thing.
That is the discretion that is exercised by the Executive Committee, my lords, or the District Council. It is not something that would vitiate the law.
But one thing you see, like district councils got 3 distinct arms, right?
My lords.
So now this is an exercise legislative function of the district council in passing the amendment, bill.
My lords.
Now whether the executive committee, which is the executive arms council, can encroach upon
The legislative function, my lords.
of the council in committing
In
that.
my humble submission, my lords, that is not even a consideration.
Why?
Why? Because, my lords, what had happened is that the matter went before, it is an admitted position, my lords, that the bill went before the House.
Before, yes.
Yes,
After
it went before the House, my lords.
Right.
The House deliberated on the bill, my lords, and a certain bill was passed. Now, there were certain observations made by the Law Department with regard to a certain expression that was appearing in the amendment bill. To that limited extent, my lords, the matter was sent back. And that was agreed to. Because if at the most, my lords, could have been a typographical error or an error, my lords, which was did not have a bearing on the Parent Act per se. So therefore, my lords, there is no question of the matter again going back to the floor of the House.
There is a distinct clause which is asserted in the amendment with regard to land administration.
My lords, it's an expression. If I can just take your lordships back to that page.
See, we have to, like strike a balance, or find out a interpretation as to whether this observation will amount to reconsideration. Notwithstanding any, because District Council Affairs, it's part and parcel, the government will act or advise District Council Affairs, correct?
My lords, to that extent, my lords, there was, I had the occasion to argue a matter before this Honorable Court, and this Honorable Court had passed a judgment on that. It says that the recommendations made by the District Council Affairs Department, my lords, would not per se be binding on the District Council.
Will be binding.
Would not be binding.
Exactly, not be binding.
It is not binding. So the law, my lords, as I humbly submit before your lordships, is settled on this, that any kind of
Which judgment
recommendations.
is that?
Well, it's what was that CM's name? Latiplang Kharkungor versus my lords, State of Meghalaya. That judgment was authored by my lords, the Honorable the then Chief Justice, not Justice Mir, thereafter my lords.
Justice?
Not Mir, my lords.
Anyway,
Well, so this issue was, well, let's discuss threadbare on this issue, that whether any observations or
can you
recommendations.
clear the judgment?
Well, I'll place it. Whether any observations or recommendations by the District Council, by the District Council Affairs Department would be binding or would have any kind of effect. What is the effect that it would have on the District Council?
But see, the court's concerned whether it has any effect on the separation of powers, basically. Like, the District Council is, the 6th schedule, the mini constitution.
True, my lords.
It has, given, though the District Council have been constituted under that, it does not have plenary jurisdiction.
It does not.
It doesn't have plenary powers. Its powers are limited to
Well,
paragraph
3.
Yes, paragraph 3.
This
and
law is
paragraph
enacted
3, that
under
is the
3G.
law-making powers which the District Council vested with.
My lord.
Now, executive functions are different. Now,
Well,
in this case,
this-
what has happened is that there seems to be, an overlap with regard to the, the authority that should have, sent back the bill
My
for
lords,
assent.
92 would come into play
Yes.
only when, my lords, the governor makes an observation.
Of course, no quarrel with that. But we're just trying to ascertain the status of this observation made by the law department, which was acted upon by the District Council, but not in legislative capacity.
In the executive,
In executive capacity. That's the only thing. Whether that action of the District Council would invalidate the
In my humble
passage of the
submission,
bill.
my lords, it would not.
Yes, they have satisfied that in that. Right? That's the only thing.
My lords, two things why it would not is, A, my lords, that the state actually goes ahead, my lords, and presents the bill before the Governor Secretariat. Governor gives assent to it. So, till that extent, my lords, there is no dispute. Now, a third party comes in, my lords, and says that because the procedure under the ED rules of 1950 have not been followed, assuming, my lords, it's not been followed, therefore, it gets vitiated. Now, the only question that remains is, my lords, the foundation of that argument that it has to go back to the floor of the House is on section Rule 92 of
93, yes.
92, which says, my lords, in case the governor returns the bill, then it has
For
to go back before the
reconsideration.
floor of the House as though it is an amendment. Only to that limited extent. What I'm humbly trying to submit before your lordships is there is no occasion for 92 to come in. If 92 does not come in, my lords, then what would be the procedure?
But is that setting a dangerous precedent, Mr. Paul? Suppose some other act is, amendment bill is presented, or a bill is presented and it's sent to the District Council Affairs to put up the governor for assent. And the law department makes observation that this clause 1, 2, or whatever has to be admitted. And that is done. This is a very innocuous, this is a very small issue. But suppose it involves a larger
In a
issue.
larger issue.
Right. Suppose we talk about amendment to one of the parent acts which are in contention in many cases. Suppose amendments put forward is passed by the House, it goes to the District Council Affairs. Then they say observations are made that omit these two things. And without consultation of the House again, it's sent back and assent is given to the governor. What will be the situation then? If by your arguments that it's not necessary, it does not amount to a sort of parliamentary procedure to be adopted.
Because, my lords, I would only submit that the consideration of putting it back on the floor of the House comes from 92.
Exactly.
If 92 is not
That
there,
is why we have to understand and see whether that would be attracted, when 92 would be attracted in such circumstances. That's all.
my lords.
Whether observation, even if the governor's signature is not there, to say the governor for reconsideration, even if given by the Council Affairs Department, whether it'll amount to a reconsideration when the District Council acted upon it. That means be reconsidered. If your argument is that it doesn't matter, it's not binding, well and good, they have just passed it again, right?
But here they have acted upon
But
part of
acted
it.
upon observation made.
Part of it, my
So
lords.
that amounts to a reconsideration per se has been done by the District Council, but not in the floor of the House by the Executive Committee. That's the only thing. If you go strict, the fine line that we define, yes, your case is very attractive. But if you go look at the larger picture, then it's a bit cloudy.
That, my lords, I would have to satisfy your lordships on whether it could have been done at the level of the executive
Let
committee
us
or
do
whether
some
it had to
research
go.
also. We will look
lords.
to it. We will have that a very interesting point.
My lords. But, my lords, in substance,
Please file that.
I'll file it by way of an affidavit. I'll file it by way of an affidavit, my lords.
Yes, you can supplement the affidavit if you want also. It's a very important question.
Yes.
Because if some finding comes out from this court, then that should not be enable the executive committee to be given a license.
Yes. Yes.
You know,
Exactly.
to tread on the toes of the legislative aspect of this council.
The House passed the bill, House dispersed,
Yes.
and Executive Committee will
Status here, my
exploit.
lords. Status here before your lordships.
Yes, Mr. Amit Kumar, we will.
Yes, sir, that issue is very important and vital for interpretation. But if the lordship will see this provision, Rule 92 or 93 of 80 rules in comparison to Article 200 of the Constitution of India. In
Yes.
Article 200, there is a mandate that it has to be placed before the Assembly. There is no such mandate in 92 and 92 million. So in Rule 92, if we do the contradistinction, there is no requirement that it has to be placed before the council, Lord. And recent judgment of Supreme Court in that Governor's case also, Lord, it will throw some light on this aspect. We will place that aspect also.
You kindly please bring whatever materials. We will like appreciate whatever assistance we get.
We'll try and assist your lordships on this, my lords, but
Interesting point, very interesting.
Important issue.
I mean, academically.
my lords, I would only submit, my lords, that 93 comes into play only in certain circumstances.
No, we accept your arguments. Yes, but then there are other questions that fall after
Well,
that.
it's-
That's only
Post that something. To that extent, my lords, I'll also seek instructions from the district council.
matters at some length. Post for further hearing on
After a week, subject to lordship.
after.
After a week.
Yes, after
Well,
1
my
week.
lords, let it be after 2 weeks, because this would
After 2
require a little bit of.
Yes,
If they apply.
the sixth schedule is a big grey area.
My lord, it's very
Not
important.
like that. It throws up many things.
Item
Yes.
number 6.
Yes.
Well, this is an appeal, my lords, directed against judgment of the learned single judge concerning, my lords, the pensionary benefits to deficit school teachers. Now, before, my lords, I get into the matter, what had happened is there is another connected matter that is pending before the bench 1 of this honorable court, presided by Honorable the Chief Justice. There, my lords, what has happened is that pursuant to a remand by the Honorable Supreme Court, my lords, some kind of draft rules under which these deficit school teachers have been made, my lords, beneficiaries of pensionary benefits has been circulated. And some orders have also flown from this Honorable Court. So, my lords, I pray a little time be granted to us so, my lords, we can ascertain exactly what is the position. Because the state is in the, state has circulated something called the draft rules.
Yes, Mr. Advocate General. Is that correct?
Lordship, I'll have to take instruction, Your Lordship.
Oh, Mr. Additional Advocate General, sorry.
Lordship, we'll have to take instruction, Your Lordship.
Yes, Mr. K. Policy Council has submitted that it conceives the matter
Punishable.
in another case pending for the
Courtmaster.
Division Bench 1. Yes, and a draft scheme has been generated by the state of Meghalaya, which is still under consideration. Therefore, prays that the matter be
What
adjourned
is the order by which those
to
draft
await any other developments. Yes, Mr. Anishulai also prays without obtain proper instructions before the next date.
If it come after 3 weeks, Your Lordship, can you allow us 3 weeks time, Your Lordship?
The list of the 3 weeks is
Lordship, highly apply, Your Lordship.
true. Since Mr. Devnath, he does not argue this matter. Next time if we... Okay, 3 weeks, yes. Why you don't argue this matter? Yes. Eurofile rejoined. Eurofile rejoinder. Have you filed it?
Lordship, we have.
Have you filed it?
Lordship, we have not filed. We have sought in the last occasion. But Lordship, here the other in the last occasion. But Lordship, here the other respondents have not filed.
Are they will file in Bihar Zone 2 shall suffice? Today, Mr. Tidahar Pace will allow further time to file rejoinder. Stop as the sections could not be obtained. The sections could not be obtained. Accordingly, list this matter after 2 weeks in the order column. Yes.
And Lordship, this respondent number 5, Lordship, whether they'll file their affidavit or not.
They are not appear also.
So.
Okay, 2 weeks, yes. Becomes as a charade.
Lords, I beg to mention item number 18 of the hearing list minutes. May I just be granted about 2 weeks' time to obtain further instructions in this
Where's
matter?
the order of the Bombay High Court?
So what's happened is that an appeal has been preferred by Tilaknagar before the Learned Division Bench. Now, we have given a concession that we will neither press that judgment, not give effect to it, or not neither rely. Yes, my lords, before the Division Bench. We won't rely on the judgment for the time being, till such time that the appeal is disposed of. So I need some further instructions in this matter. Kindly grant me about 2 weeks, my lord.
Mr. S.N. Prince was allowed 3 weeks for them to obtain instructions on the matter. Yes. This thereafter. Yes.
Obligement.
Yes. Number 20.
Not 20, my lord. We need certain instruction in the matter, my lord.
Who's the pairing? 20. Yes.
Lordship, in this matter, my lord, it appears that LOA is already issued. So in that view of the matter, LOA, my lord. In that view of the matter, my lord, they may not be interested. So we just need some instruction whether they still...
Okay, Mr. S. Thapa submits that the matter may be able to then infructuous.
Not infructuous, my lord, whether they are still interested to pursue or not.
Mr. S. Thapa submits that perhaps the writ petitioner may not be interested anymore in pursuing the matter. He prays we allowed to obtain instructions. This after 2 weeks is... Yes. Fun.
Supplementary list item number 1.
May please, Your Lordship. May please, Your Lordship. I beg to mention item number 12.
Why mentioning now after the message stop?
I'm about to mention, Your Lordship.
Yes.
Let this matter may come after 1 week, Your Lordship. Which matter? No. 12.
Oh, the hearing is totally gone. 1 week, okay, yes.
Highly obliged, Your Lordship.
Can't deny you since all others.
Maybe 2 weeks, Lordship. I'll be out of station, my lord.
You're there also?
Item number 12, Lordship. 12.
Then you mention which matter?
I mentioned the matter, Your Lordship.
No. Yes.
Yes, Your Lordship.
12, okay, 2 weeks.
Yes, 12.
Much obliged, Lordship.
May it please, Your Lordship. Your Lordship, I beg to mention item number 22.
Number?
22.
22. Mr. Siddiqui is here. Where's Mr. Siddiqui? Have you informed him?
Yes, Your Lordship.
Yeah, I'm appearing on behalf of respondent number 4, Your Lordship.
Where's the petitioner?
I have informed him, Your Lordship.
Why are you taking time? Have you filed affidavit?
We are not prepared, Your Lordship.
No. Have you filed affidavit or not? Lawyer is supposed to be prepared every day. The matters in the list, yes.
Yes, Your
You
Lordship.
file affidavit or not?
Yes,
It's been
sir.
filed. Don't understand this. Okay. After 4 weeks?
1 week,
3
Your
weeks?
Lordship.
1 week, okay.
Supplementary list item number 1.
Yes, Mr.
My lord. My lord, item number 2 may be taken first. They originate from the same set of facts.
Number?
Item number 2, my lord.
Number 2 is what?
No, it's a contempt. No, it's a contempt. Contempt, my lord.
Contempt against what which order?
My lord, contempt, my lord.
Contempt against what which order?
My lord, it's against the judgment. It's against the judgment and the directions passed by the Apex Court. Least to say in Arnesh Kumar versus State of Bihar, my lord, and then the judgments which have come out of it.
With regard to manner of arrest?
My lord. Not just
41A?
41A, and also, my lord, the recent pronouncements where the grounds of arrest were not explained to me. My medical reports were changed. My first medical report said, my lord, if we...
What is it?
My lord.
Yes.
The police personnel come over to my residence, they drag me and they take me from there, my lord. This is the intimation of arrest given to my wife. Now, my lord, see that there is no grounds of arrest which have been mentioned in this intimation of arrest as to what is the reason and why am I being arrested. And that too, my lord, in lie under the umbrella of 41A which was given to me and I was abiding by it.
Yes.
My lord, it says, it is to intimate it to you that Shri Pankaj Gupta @Pintu, who was been arrested in connection with the case under reference at Tura on 14/1/2025 at 5:30 AM, has been held in custody at Bajengdoba PS lockup under police custody. It's left blank, my lord, given by the IO. Now, my lord, page 42.
Yes.
My lord, is the medical. The type copy is at page 43, my lord. My lord, the date of examination 14/1/2025, time 3 PM.
Yes.
My lord, page 44. The last entry in the opinion. In view of his high recorded blood pressure, patient is newly diagnosed severe case of hypertension and thus is not fit for a lockup.
Yes. What happened after that?
My lord. My lord, page 47, annexure 8. My lord, type copy is at page 48. Date of examination 14/1/2025, time 7:50 PM.
Yes.
My lord, as the new patient is a newly diagnosed severe case of hypertension patient, the patient can be kept in lockup.
Where is it written?
My lord, page 49 is the type copy. The last entry, my lord.
Yes.
As the newly diagnosed severe case of hypertension, hypersensitive patient, the patient can be kept in lockup. My lord, on the same day, first after serving me a notice of 41A, my lord, and me continuing to abide by it for a period of over 7 months, suddenly I am dragged and taken from my residence. When the doctor opines that I am not fit to be kept in a lockup, my medical documents are changed, my lord.
Yes, but just arrest, what did he say? Why is custody necessary?
My lord.
Why have they said that custody is necessary?
My lord, they have not stated any grounds as to why is it necessary. The only ground stated by the investigating officer at a
cooperate with the investigation.
My lord, he says because I did not confess to my of crime.
What new evidence has come to light?
My lord, nobody knows.
Yes.
My lord, the law is settled in this. My lord, Arnesh Kumar.
Yes.
If I may, my lord.
Yes.
Please. My lord, page 19, entry 7.
Yes.
Failure to comply with the directions aforesaid shall, apart from rendering the police officers concerned liable for departmental action, they shall also be liable to be punished for contempt of court to be instituted before High Court having territorial jurisdiction. My lord, this judgment has been very vehemently reimposed in 2022, my lord, in Satyendra Kumar Antel. If I may, my lord. My lord, page number 445, para 73, my lord.
Yes.
My lord. My lord, 73B. The investigating agencies and their officers are duty bound to comply with the mandate of section 41 and 41A of the code and the directions issued by this court in Arnesh Kumar.
Are you on bail now or are you still?
I am on bail now, my lord.
Okay.
I was.
Yes. Heard Mr. Nkera in item number 2. If you notice as to why proceedings under the Contempt of Courts Act 1971 been initiated against the respondent on the allegations as contained in the petition. Stop. Even how you take steps.
My lord.
I should resume. Let the author. Let yes. Be not initiated against the respondent for the allegations contained in the contempt application. Yes, the contempt application of petition. Stop. Steps were taken within 3 days. Just after 2 weeks. Where's the FIR?
My lord. My lord, Annexure 1. My lord, page number 22, the folio starts,
Yes.
and the FIR is at page 24, my lord.
Read the FIR. Yes.
My lord. My lord, page 22, entry 8 will show the name of the accused. The folio which they have prepared, my lord. The only named accused is Pankaj Gupta, my lord, at entry 8. My lord, page 27, annexure 3.
No, who filed FIR?
My lord, one Starson Marak has filed the FIR.
Who's Starson Marak?
My lord, he claims to be the owner of a license holder of the PDS, public distribution under public
How are you
distribution scheme.
connected to him?
My lord, I am not connected to him at all. I am not connected to this case at all.
No, the other case, the
Pankaj,
how
my
is
lord,
connected
it
to-
is alleged that I am his manager.
Okay. Let's see what does the FIR say?
My lord.
Okay, Pankaj Gupta. So.
May I, my lord?
Yeah, please.
My lord. Sir, with reference to the above subject, I crave leave to state that I hold dealership for PDS under FSA as wholesaler for Resubelpara Center, Mendipathar Center, Daina Dubi Center and Gokulgure Center. My wholesale unit is managed by my appointed manager Shri Pankaj Gupta @Pintu, son of Shri Hare Krishan Gupta, a resident of Anand Mat, Tura, West Garo Hills district, Meghalaya, since the month of August 2022. All the affairs of my supply business is managed by my said manager, which includes lifting of stocks and distribution to various retail units. Of late, after having scrutinized my accounts and records, both from my office and the concerned my said manager without my knowledge, had siphoned huge quantity of PDS rice issued under allotment for the month of December 2022 by way of lifting the stocks and selling the same in the open market at market price, thereby depriving the genuine villagers from getting their respective quota for the stated month. The quantity of PDS rice so lifted by him under regular allotment is described as under. In Lemine, my 2020 food grains never reach the beneficiaries. The details under PMGKAY lifting includes as under. Furthermore, my said manager had lifted supplies under MDM allotment for the month and year indicated below, and the said food grains never reach the beneficiaries, school going children. The details under MDM lifting includes as under. Sir, it's worthy to mention herein that I have been managing the short supply for the stated period by adjusting the supplies with the buffer stock I maintained, which is otherwise supplied by the concerned authority. However, at certain point of time, I am to make good the deficiency of 6121.62 quintals of rice, which is worth crores of rupees as per market value. The illegal action of Shri Pankaj Gupta @Pintu not merely becomes an offence of cheating under the various provisions of the Penal Code, but also criminal breach of trust and under the provisions of Food Security Act as well. I further suspect that the food grains siphoned by Shri Pankaj Gupta @Pintu has been illegally sold to various traders of the nearby market who have knowingly purchased the government stocks with malified intent of wrongful gain. Lastly, for past many months, I have been trying to contact Shri Pankaj Gupta @Pintu and his mobile number so-and-so and so-and-so after ascertaining his scam, but to no avail. He remains absconding after...
Okay. Yes, now what is the... Now, this person...
My lord, page 27, annexure 3.
Yeah.
I have been also dragged in the... At night, my lord.
You're the brother of Pankaj.
I'm the brother. I have been arrested. The intimation of arrest shows it. My lord, never was I forwarded to any court.
You kept custody for how long?
My lord, I was kept in custody till 10 p.m. on that night and then I was kicked out of the police station. Morning, 5:30. Now, my lord, post-release, my lord, there has to be a document they will show that I was released on bail. There is no document. Now, my lord, interestingly, what happened, while my brother was in custody, we were being forced to sign certain agreements with one person, my lord. We have made that averment in our petition pleadings.
What agreements?
My lord, we were forced to enter into an agreement with one Gautam Prasad that we have to pay him certain sums of money to the tune of 1 crore plus. My lord, we were also forced to sign blank papers in the police station.
So there's more that meets eye. Anyway, okay,
my lord.
You should notice his MSZD non-country when a G is present except notice on behalf of
1 to 4, your lordship.
1 to 4. All the respondents.
1 to 4, your lordship. Number 5 has been named personally.
Yes, as the 715 been named in person, notice issued 715 registered AD within 3 days. List after 2 weeks together with the contempt matter. Yes.
Hello, please.
Obliged, your lordship.
Item number 3.
May
please, your lordship. Lordship, before our senior will proceed, I would like to request to accommodate next week. So our lady counsel is not available, Salman Khurshid. So due to his non-available, so
no problem. But the thing is, this you're challenging the order of the speaker.
Yes, we are challenging the order of the speaker.
For is it rejection? Total rejection of
representing the speaker, my lord.
Yes. Yes.
I am representing the speaker, my lord. The copy which has been served is also not complete. And let it proper copy be served on us, my lord, because neither
yes, we will do that.
is there, no details are there, my lord. And
yes.
Then my friend is requesting for accommodation. Your lordship may have it on 8th or 9th, my lord.
No, your lordship on 2nd. If yes, second.
Second of
me.
Second, this court will not be there.
Okay. So on 8th.
On 8th, yes. Mr. K.V. Khalindo, Council President, praised that the matter be taken up on 8th of May due to unavailability of the arguing senior counsel staff. As for Mr. A. Kumar appearing for the speaker respondent, yes, has also submitted that a legible copy has not been supplied to the respondent. Yes, according to the matter on 8th, supply extra copies of legible copies of the petition to the respondent. Yes.
Item number 4.
For 24 early hearing of the main writ petition, my lord. And the petitioner has filed their rejoinder against our affidavit in opposition.
What do you mean early hearing? You can come and mention it. You don't need application for. Why do you have to file an application for early hearing?
By way of an mentioned memo, lordship. And lordship had already fixed a date on 5th May. It's very early.
Already fixed on 5th, so my
yes, 5th May, like as the miss case has been filed, the incident is filed for early hearing on PC number 19 or 2025. Stop. It is submitted by learned counsel for the applicant that the pleadings also complete in the matter. Stop. As it is informed that the matter is fixed on 5th May, let the matter appear on a fixed item.
Lordship.
Please come. Yes, for hearing. Miss Case stands both of yes.
Daily list item number 1.
So item number 1 is inadvertently showing in the motion list. This is already moved on the 1st, and lordships are directed notice to be issued.
Yes.
So notice with regard to the private respondent has not yet been
appearing.
served, my lord.
I am entering appearance on
Fine.
the respondent number 6.
Yes, Mr. S. A. Sheikh entered appearance on behalf of respondent number 6 today. As such, notice complete all respondents.
Lordship.
Yes.
I'm for 1 to 3, Lordship. Your Lordship seeking indulgence of the court at least 3 weeks' time for affidavit.
What about MPSC?
MPSC.
Lordship.
Yes, Mr. K. Khanal AAG Utsunso, MSPF along for number 5 and 4 and 5, and S. A. Sheikh for number 6, 3, 4. Allowed 3 weeks' time to file respective affidavits. Yes.
Obliged, my lord.
All right.
Item number 2.
Please, Your Lordship. Lordship, I pray for some more time, Lordship,
For?
to file a rejoinder affidavit, Lordship.
Who's for number 4?
I am for the 5, Lordship. 4.
None for 4. Who's 4?
Yes.
4 what respondents for?
Managing Committee, Lordship.
It's going to expire against 4 or no?
That Mr. A.M.U. Ahmed entered, appeared.
Where's Mr. M.U. Ahmed?
Later on, he has withdrawn, Lordship.
They're not represented any longer.
No, Lordship.
What to do? You take fresh steps again?
Fresh step, Lordship, yes, Lordship.
Yes, sir. You know, file the joint
Lordship.
MSD. So, the crew, sir, please be allowed to file a rejoinder to the affidavit filed by the state respondents. Have you
And
filed
I
affidavit?
I have filed, my lord.
Yes.
And respondent number 5,
And
Lordship.
number 5, stop. With regard to respondent number 4, it is informed that the counsel is appearing for the said respondent has since withdrawn himself from the case. As such, it's directed that the petitioner take fresh steps on respondent 4 within 3 days. Just after 2 weeks.
Highly obliged, Lordship.
It should be listed in order column, Lordship. Order column, Lordship.
Yes?
In the order column, Lordship.
In the order
In the order.
In the order column.
Must.
It's in the hearing.
The admission.
Admission hearing,
Sorry,
Lordship.
admission. Must.
Item number 3.
Lordship, here I have filed an affidavit for challenging the maintainability.
You want to file objection? No.
My lord.
Where's the affidavit? When did you file it?
Lordship,
We have not received any instruction.
Lordship,
Since
13
March.
Since March, Lordship.
Yes.
My lord, we will not file any rejoinder, my lord. We will not file any rejoinder.
Yes, okay. You start.
Lordship,
One today.
Good question. Since been resolved, he please be allowed to withdraw his petition. Same is not objected to by the respondents, or not. It's not objected by the respondents. So, in view of the submissions made by the counsel petitioner, matter stands closed for withdrawal and is disposed of. Yes.
Item 7.
My lord, in this matter, the private respondent before they had filed the affidavit, and if I'm not mistaken, the other respondents had made a submission before this honourable court previously that they will not file any affidavit. We are not going to file any rejoinder. We can, my lord, can fix for hearing them.
Just, which you file affidavit?
No, no.
Who file affidavit?
Only respondent number 4.
You're the headman. It is submitted that the respondent number 4 has since filed the affidavit. As the other respondents will not be filing their respective affidavits, we'll suppose admission hearing stage. This is a matter of admission hearing. Yes. After 2 weeks.
Item number 8.
Page 16, Lordship. Page 16.
Page 16, Your Lordship had directed for reinstatement, Lordship. Thereafter, Lordship, at page 19,
Yes.
they had placed again under fresh suspension, Lordship.
Okay.
Now the division bench order, Your Lordship, I have seen at page 23, Lordship. Division bench says that only if on a different act, Lordship, then they can place me under suspension, not on the same cause of action. So till date, I'm still under suspension, Your Lordship. And even the back wages also have not been fully paid, Lordship.
You file even today?
Well, today I cannot, Your Lordship. It's ready otherwise, my Lord. She is on medical ground on leave. She is joining you.
After 1 week, Lordship.
It's just a matter of 1 week. Expected by next date. After she'll be on board. Yes.
Obliged.
Hearing, supplementary list item number 5.
Why listed today?
Lordship, yesterday, because I sent my junior to mention the matter, to adjourn the matter, Lordship, but the matter was listed today because the court was not inclined to give time, Lordship. So, okay, Lordship, no issue.
No, because he said this structure is correct.
Lordship, no, Lordship, I said, why I stated yesterday, Lordship, matter was already heard, part heard.
No.
Oh.
And your Lordship has given opportunity for the petitioner to do some more research into the matter.
It was not part heard, in fact, because Lordship, my colleague, he was just open for argument. Later was the matter was not heard, Lordship.
Then you said it's already been heard?
Lordship, it was heard substantially by the petitioner. But then since the petitioner could not substantiate his claim.
So you're putting the court in circles, making it the court run in circles also.
Lordship, my apologies, Lordship. I said again, Lordship, the petitioner had already started his arguments. Lordship.
Petitioner already concluded arguments.
No, Lordship.
He started arguments and but then Lordship had given time for him to
So
do
now
some more
unless the
research.
matter will indicate it's part heard or not.
It's not part.
Yes, under prayer when it comes to petition, this is a matter for 2 weeks. Yes.
Must.
Item number 6.
Where's Mr. Shulai? He's the most.
Lordship, the main
He's the
is
most,
the central government. Lordship, I would like to place this regulation here. Lordship, we'll just have a look at it. The rules, in fact.
My Lord, regulations will not help, my Lord. But the petitioner should specify, my Lord,
I'll specify.
what are the amounts due to him, my
That's
Lord.
what he said. He's come up to amounts.
I'll come with that.
You've given a chart to him.
You
should have given it before that, Mr.
This is
Marpan.
something that they are aware. They are doing the calculation.
No, calculation. He said that the calculation, he wants a calculation.
I'll have it.
And then the court will pass orders whatever
Yes.
amounts due.
Just give me something. I'll just explain to you. I have flag marked it as Rule 45, Lordship. Rule 45, Lordship. Rule 45, Lordship. The heading is retirement,
Yes.
gratuity and death gratuity. The one which will apply to me is this 1A. May I read, Your Lordship? A government servant who had completed 5 years qualifying service and had become eligible for service gratuity or pension under Rule 44 shall on his retirement be granted retirement gratuity equal to 1/4 of his emolument for each completing 6 monthly period of qualifying service, subject to maximum of 16.5 times the emolument. I'd like to pause here, Lordship. Kindly come to the affidavit of the central, Lordship. At page 7, Lordship.
My Lord, before my friend goes, but there are 21 rules, my Lord. He retired before that. So whether these rules will apply?
Yes, will apply.
How?
Kindly see, it's given here, Lordship. Rule 2. Kindly come right at the front, Lordship, how if it applies or not. It says here, safe and otherwise provided in this rule, these rules shall apply to government servants appointed on or before 31st December 2003. So it will apply to him, Lordship. Para 7, page 7.
No, that will, in my humble submission, my lord, that will not apply, my lord.
Let me complete, Your Worship. Let me complete, then they can reply. Para, page 7, Your Worship. Annexure 3 of the affidavit is sent to the Your Worship. Page 7. Annexure 3. Page 7. Your Worship. Page 7.
Yes. Yes.
Yes. The portion where it says gross service from 1st November 1999 to 30th September 2021. The calculation here, period they have mentioned here, starting from 1st November 1999 till 30th September 2021, the calculation, can you see, Your Worship? There's a 22 years given there. 22 years of service. That's the calculation they have come up. 22 years.
How?
It's there. It's mentioned.
Months.
44 monthly period, 6 monthly period. 22 years, if you calculate in 6 monthly period, is 44 monthly period.
99 to 21.
Yes.
Okay.
So they have excluded the 10 years, which is missing. It's 22.
With the state respondents.
Yes. So 22 years. Now the calculation is in the next page, page 8. Under retirement gratuity, pay matrix plus DA, DNS allowance. The emolument comes to 50,944. Now, if you calculate using the rule 45, where it says, you can see the calculation, 50,944 into 1/4 into 44. 44 is 6 monthly period.
Okay.
Total comes to 5,60,384.
Okay.
So rule 44, they have just applied the first portion where it says 1/4 of his emolument for each completing 6 monthly period. So according to them, I have just completed 44 6 monthly period. Now
No. 44 is 44 monthly periods.
6 monthly period. 22 years of service. They have taken only 22 years of service. Now, if we take in terms of 6 monthly period, is 44 for the sake of calculation.
Okay.
I don't know if you got that.
No. Yes.
Their calculation is
Let's
this.
understand it, yes. Their calculation.
Focus on the 44.
Yes.
Now, come back to rule 45 logic.
Yes, that's 14.
16 and a half.
16 and a half. Now the
16 and a half times.
Now the bracket below the great gratuity in 1/4 emoluments coming half year or subject max 16 and a half times.
16 and a half time. If we calculate in the number of years, will give 33 years of service.
So you mean to say add the 10 years, you have 32 years only?
No, not 2 years.
Then?
If we add 10 years to 22,
yes,
it'll be 32.
32, that's what it's good saying.
So the maximum is 33. 33 is the maximum. Now, if we take in 6 monthly period is 66. So the figure that should come instead of 44 should be 66.
Multiply by 66.
Multiply by 66. Now, if you multiply by 66, the figure of 5,60,000 would come to 8,40,576 exactly. That is the figure.
That is what you are due.
Yes. So, if you minus the amount that has been paid to me, the amount which is paid to me so far is 5,60,000, which is mentioned in the affidavit. The balance is 2,80,192 rupees is due to me. And not only this, now because of the delay, administrative lapses has occurred. Now there's a rule which is for the interest that has to be added.
What percentage?
The percentage is 7.1% as a GPF, the current rate. That is under the rule 65. I flag mark here.
Yes.
Rule 65 explains.
So 6% will come to how much? From the date of
Total.
21
Total.
is the date of entitlement.
Yes.
Date entitlement to date actual payment.
So 7.1% for 3.5 years delay The amount of interest is 69,627 rupees. If we add 2,80,192 rupees, the total balance due to me is 3,49,890 rupees exact. Maybe more than that. This calculation till March last month.
Yes, Dr. Mosika, you agreeable to this calculation?
My lord, let him file an affidavit indicating on what
I have the
on what head.
calculation.
File an affidavit. I'll reply to that.
Not affidavit, I'll just show the calculation. It's very simple. Affidavit is just complicated.
The case has taken a totally different turn now. The case was that
because it ran entitlement because that document was produced regarding the deputation, whatever continued deputation.
That the state has already conceded also.
They're already conceded, right?
Exactly.
Mr. Shulai?
State has conceded.
Yes, please that was your lordship because from the additional file affidavit filed by my friend your lordship, his lordship kindly comes to page 17. Your lordship. We have extended that till 1999. There is also a stipulation.
So the gap goes.
Yes. I am entitled.
Whether this
and as for the office memorandum also of
we are a court of
1986 is very
record. So sir, you file an affidavit, then we'll settle it.
File an affidavit giving calculation that on this head, is entitled this much, on this head is entitled this much.
An affidavit saying that see, by virtue of the statement of the state with regard to covering the period up to 99 when he was sent to on deputation to Negrims and having retired from there, so your your entitlements will arise from that period, and the 44 like monthly periods, that's the service under Negrim 22 years, 10 years have to add it to the 22 years, which will bring your entitlements instead of 5 lakh 60 to 8 lakh something, and factoring the interest at 7.1%, that's the amount you should get. You put an affidavit, let them chew on it, and we'll pass orders.
Rule 45, what I understand, 20 years and beyond, my lord. His services been counted 22 years, my lord, you've seen. Now 20 years plus. Now 20 years plus can be 22 or 32, doesn't make any difference.
So it'll come same amount.
It'll come to same
that
amount.
means the basic 44 monthly periods, that's it.
That is incorrect. Yeah.
Let him file an affidavit.
You file it, yes. Mr. Marpan today has elaborated before the court the entitlements, the entitlement to internal benefits of the writ petitioner with regard to the period, the total period that he was in deputation before Negrims. Stop. He prays that he be allowed to place the same by affidavit. Stop.
Giving exact figures, my lord. You should give exact figures so that I can have proper justification.
Wherein the exact
give me 2 weeks because I see petitioner is in Garo Hills, so
will be exact figures will be provided. Yes. Praise allowed this after 2 weeks. Yes.
Right.
If that's the case, see. Anyway, let them file will pass orders.
Daily list 10.
Yes.
Please, your lordship. But I have instructions. This matter can be disposed of. A similar matter has been disposed of by Guwahati High Court, my lord.
Is that correct?
Yes, my lord. In that case, my lord, your lordship may kind.
How is this overlap in this investigative process? We don't understand. How can it happen? How is this overlap in this investigative process? We don't understand. How can it happen in this day and age?
My lord, there is a simple direction to them to. One direction is to freeze the amount, my lord, and the second direction is to make a demand draft and give it to. And in terms of the PML Act, my lord, that has been approved by the authority, my lord, under Section 8 of the PML Act. So now the bank has no liability, my lord. Bank is only the custodian of the amount of the account holder, my lord. So that's why, my lord, the Honorable Guwahati High Court has said, my lord.
Now, so many cases are floating up even out here. And yesterday we had 2 matters. In this.
In fact, there's one PML case has been charge sheeted here. There are 200 accused persons only. They're all chit fund companies only.
What orders are, let's see?
There is slight difference, my lord. Because there was an NOC by Nagaland police in this case. Here the notice the notice issued to Hyderabad police or no?
We have already taken steps, my lord, and as per the my lord take consignment report, the notices were delivered to the address, my lord.
When?
It was delivered on 19/4, lordship.
Take it next date, Dr. Mosika. This is the first time it's come up.
Lordship.
After motion.
Yes.
Yes.
Where you say that you have received?
So one notice from Hyderabad police, I think.
Yes.
What page is that?
Because you only need them to appear. Because if they have nothing to say, then then the amount can be deposited with ED.
ED, my lord.
Yes, my lord.
Yes, it's for hearing today.
Orders, my lord.
It's for instructions, my lord.
You said they've been served. That means
Lordship.
they've been served.
Yes, my lord. I may be allowed to file an affidavit
You have to
regarding
file
this, my
that,
lord.
because that's to go on record.
Lordship.
Like I keep on saying, after we have a code of record.
Yes, my lord.
Then the matter can be, if they don't appear, it can be
Then
disposed.
yes, is submitted by Mr. Pitas that the respondent's number 426
456, my lord.
426
Lordship,
566 have
lordship.
since been served. So he prays be allowed to place the same on record with affidavit on the next date. Prayers allowed just after 2 weeks. Yes.
There is an interim order, lordship.
Yes, for
that may continue.
For appearance of the respondents for filing affidavit or filing of service affidavit. Yes. So interim order when he shall continue next day. Yes.
Obliged, lordship.
15.
You correct, because in that case, I just had the order. They have no objection. One and two.
Nagaland police had no objection.
Lordship.
May I please, your lordship, before I start my case, your lordship, I beg to submit that, your lordship, from 23 November to 24 November, September, the matter was for respondent number 1, no instruction. Then matter was handed over to another council. Another 6 months has gone, no instruction.
Who's number 1?
MHRD, Union of India. So now Debnath is appearing, and every time Mr. Debnath, your lordship.
Where's the Debnath? He was here in the morning. Catch him, bring him here.
Your lordship, I have a small prayer also, your lordship.
It's not.
I have a small prayer, your lordship. In that case, my learned counsel may file one small affidavit whether step has been properly taken or not to bring on record, because every time they are saying seeking instruction but no record.
You know, Mr. Debnath is the most successful central government standing counsel.
2.5 years gone, your lordship.
He can avoid all cases.
Matter is listed in the. Then
it's very difficult to pass orders against Debnath. He avoids cases very deftly. So very difficult.
2 and 3 years already filed, but
2 and 3 years already filed?
Already filed long, and why it is only for pending for hearing, your lordship, because
2 and 3 years university.
Nehu and UGC.
Who has to file? Only number 1.
Only one is
What
left.
is your name?
My name is Kongkao.
Name is?
Kongkao.
I can't hear you.
My name is Kongkao.
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 You with Mr. Debnath for how long?
I think for 4 months.
4 months. Have you read the brief? Have you read the file, this case? Have you seen? You don't know what's in the brief also. You have any idea what the matter is about?
I'm not so thorough with it.
Not so thorough, but you know what's the case about, correct? How many years you practice, or how many months?
Now it's running 4 to 5 months.
You practice 4 to 5 months. This is the problem. You send the raw juniors, you don't know anything, put them in line of fire. What instruction did you get?
I didn't get any instruction. I was advised to be here since he's engaged in some other matter.
He's here in the court.
Yes.
You just go look for him, bring him here. I mean,
Sir, he's appearing in court number 3 for hearing now.
You bring him here, call him. Mr. Debnan. Can't be so casual. But that is his style of operation. I'm not sure hearing. This scheme is over.
Scheme is over. At least your lordship before.
But is there any?
Yes,
it's not the hands university to continue the scheme also.
Scheme is over, but your lordship, how long? Because she last drawn salary was 47,000 plus, your lordship.
But then?
But suddenly it was that SRC was owned up, and following that they were jobless, but no terminal benefit, no prior notice of termination or anything, no retirement benefit, no terminal benefit, nothing. How after 26 years of service, and as per Nehu's affidavit, your lordship.
What about the other states in Nagaland and Mizoram?
And that is, your lordship, I am not aware. I am not aware.
The state project officers have appointed.
I am not aware. As per Nehu's affidavit, your lordship, SRC was dealing since 1998, but appointment was given by Nehu. So there was it not proper for the Nehu to give notice to the petitioner for dealing detachment of SRC?
Initially, my lord, financial and other control has been entrusted on us. So these continued till 1998. 98, my lord, there was a direction to hand over everything, including financial validity, to the directorate of that resources. Formal letter I have annexed. We have handed over everything in 98, my lord. After that, we are not in touch.
So at least one.
So 98 till when was your engagement?
94, your lordship. 94 to 2018, continuous without break in service.
When you come to court?
23, your lordship.
After 5 years.
5 years, because up to 20 they wait.
I don't want to say, the court won't say, but please, Mr. Devnar, the court's talking to you. You want to argue with your junior outside? Have some respect also. Why isn't affidavit from your side till now?
I didn't get any instruction here.
Then don't appear anymore. We'll pass orders. When's the last communication you had?
I have sent this year, no in-person.
This year?
This year, after getting it.
You take down Mr. R. Tebnat, who's appearing behalf, CGC appearing out the spot number 1, has submitted that in spite of him informing the concerned respondent.
On 24th day of October 2024.
We're not going to record that. In fact, we're going to use repeatedly. He has received no instructions. Stop. It is surely never a sad state of affairs when no assistance is provided to the court, especially when it concerns a litigant who has been, it concerns a litigant who claims to have been deprived of her employment. Stop. As Mr. R. Devnath seems helpless in the matter, a copy of this order be now that MHRD, what's it called now? What ministry is it called now?
Ministry of Education.
Ministry of Education.
Ministry of Education.
Ministry of Education. Ministry of Education. Why do you write Human Resources?
Your lordship, it was prior to 23. I filed this.
Yes, let a copy of this order be sent by registry to the Secretary, Government of India, Ministry of Education. bracket erstwhile Human Resource Development, New Delhi 101. So it is expected that receipt of the order, positive steps will be taken by Respondent number 1 to ensure proper representation in the matter. Just after 3 weeks, yes.
Much obliged.
Your Lordship, I would like to mention again item number 3 of supplementary, that the disqualification petition. So due to non-ability of the senior on aid, so we request and with the permission of the speaker, the advocate of the speaker, so we request to list it on 9.
Yes, on 9.
Obliged, Your Lordship.
9.